How to handle service animals and ESA in pet screening. Are you a property manager or real estate investor wondering how to handle service animals and emotional support animals in your pet screening process? You're not alone. This topic is essential for managing vacancies effectively and ensuring compliance with housing laws. Let's break it down step by step. First, it is important to understand the difference between service animals and emotional support animals. Service animals are specifically trained to perform tasks for individuals with disabilities. Under the Americans with Disabilities Act, these animals have the right to accompany their owners in all public spaces, including rental properties. On the other hand, emotional support animals provide comfort and emotional support to individuals with mental or emotional disabilities. They are protected under the Fair Housing Act, which requires landlords to make reasonable accommodations for them. Now, let's talk about the legal requirements. Landlords must allow service animals in rental properties, even if there is a no pets policy. You cannot charge pet fees or impose breed or size restrictions on service animals. For emotional support animals, landlords must also accommodate them under the Fair Housing Act. This means waiving no pets policies and not charging pet fees or deposits. However, you can request documentation to verify the animal's status as an emotional support animal. When it comes to the pet screening process, it is crucial to differentiate between ordinary pets and service animals or emotional support animals. Start by identifying the type of animal. Determine if it is a service animal, an emotional support animal, or an ordinary pet. This distinction is vital for legal compliance. For emotional support animals, you may request documentation from a healthcare provider confirming the animal's role. However, for service animals, you should not request documentation unless it is necessary to determine the animal's status. If you do need to ask for documentation, approach the situation with caution and respect. Next, assess whether accommodating the animal would pose a direct threat to others or cause undue financial burden. If you believe it would, you may have grounds to deny the accommodation. However, this decision should be made carefully and ideally with legal counsel. Lastly, update your pet screening policies to reflect these legal requirements. Ensure that all staff members understand the differences between service animals, emotional support animals, and ordinary pets. Training your property managers and staff on these distinctions is essential to maintain a fair rental process. By handling service animals and emotional support animals correctly, you can avoid legal issues and ensure compliance with housing laws. This not only helps you manage vacancies more effectively but also ensures that your properties remain accessible to all qualified tenants.